Hello, everyone, and good morning. For me, actually, it's good afternoon because I'm in Cape Cod in a town called Eastham, Massachusetts. But I'm delighted to bring to you this transcontinental webinar. Mike Keyes of Dorsey and Whitney, an expert on survey evidence and an IP litigator of renown, has agreed to present a webinar entitled Avoiding Consumer Survey Pitfalls at the TTAB. I'm looking forward to it, and I'm sure you are too. Thank you. Thanks, Mike.
John, thank you. It's a pleasure to be here with you and with your faithful subscribers. I know we've all benefited from your insights and perspectives over the years, so it's a real pleasure to be here with all of you. Just a little bit about my background before we kick off in earnest here. I'm an IP litigation partner at Dorsey and Whitney in Seattle. The bulk of my practice, at least in terms of my trial practice, relates to trademark and advertising related litigation. But I also have a background in survey research. I completed a master's degree in survey research and data analysis. And earlier this year, Dorsey launched our consumer insights group, where we provide expert witness services, both on the consulting and testifying side, with respect to survey research. So I want to make sure to mention that to you. If you have any questions, I'd be happy to field them after we're through today, so don't hesitate to reach out. I do have a publication on LinkedIn that I wanted to mention. It's called Lanham Act Surveys for Lawyers, and it's dedicated to analyzing court decisions and TTAB orders related to survey evidence. So the QR code is right there on the screen, and would be happy to have you subscribe if you haven't already. Just a couple of housekeeping matters. The materials and attendance form, they're available to download from the events@dorsey.com email that you all received. As I mentioned, I won't be taking questions during the presentation today, but do feel free to reach out and email me directly at keys.mike@dorsey.com. About midway through today's presentation, I will be giving out the verification code for states that require it. It will be announced, and this is different from the accreditation code that you all may have. You'll see a number of states where we expect for CLE credit to be granted. And just make sure you return the completed attendance form and send it to attendance@dorsey.com. So without further ado, let's go ahead and get started. Here's what we're going to cover today. We've got an hour. We've got a lot of material, but I think we can make it through. I'm going to talk a little bit about surveys by the numbers, what we're seeing in terms of the rise of survey research, both in terms as far as federal court litigation is concerned, but also at the TTAB for certain. I want to talk just briefly about the process, timing, and costs associated with developing survey research for use at the TTAB. I'm going to mention a few resources that I commend to you, and then we'll get into the bulk of today's presentation. 10 pitfalls to avoid when submitting survey evidence and survey evidence like to the TTAB, and I'll discuss that in a little bit more detail. So let's talk about surveys by the numbers. So survey research is certainly on the rise in federal courts. You can see this by the slide here. Look at this last 20-year arc of time, starting back in October 2004 through September 2014. We saw approximately 636 decisions involving survey research in some form or fashion. And then fast forward this next 10-year period, we've seen a swell of decisions, up to 855 of them involving survey research. So we're certainly seeing a very significant increase in survey research decisions handed down by the federal courts. But this slide doesn't mention is that of approximately all of the decisions in the last 10 years in particular that the federal courts have looked at and analyzed, approximately a third of those surveys were either excluded from evidence or where the courts found that there were significant flaws associated with the submission. We've seen a similar increase, actually percentage-wise, a bigger increase at the board in terms of the number of decisions that have been handed down in the last 10 years compared to the preceding 10-year period. And I suspect we're going to continue to see survey research continued to be a prominent part of both federal court decisions and TTAB decisions as well. A couple of notable cases that went all the way to the U.S. Supreme Court involving survey research. As you all know, the Booking.com decision is an issue involving genericism, and there was a Teflon survey that was discussed and analyzed in that particular decision. Now, we're going to talk about genericism surveys and Teflon in particular towards the end of today's presentation. A lot to discuss in that regard. We could probably do a whole webinar on genericism surveys unto itself, but we're going to talk about some of the key issues that I think you need to be thinking about when it comes to genericism surveys. And then, of course, who could forget the Bad Spaniels case? There was a likelihood of confusion survey that was presented to the court there. Wasn't so much discussed by the opinion, but certainly Justice Sotomayor spent her entire concurring opinion discussing survey evidence. So I think we're going to continue to see survey research that's going to be pretty prominent in both federal court and TTAB practice. I'm going to talk just briefly about the process, timing, and costs associated with developing survey research. Now, we're going to talk about this, the manual of examination procedure, because clearly both examiners and the board anticipate survey research is and will be used in cases before them. I want to call your attention to the bottom part that I've underscored of this portion of the TMEP. The first part says survey evidence and market research can be used for purposes of showing such things as secondary meaning, but the applicant must document the procedural and statistical accuracy of this type of evidence and carefully frame the questions contained therein. I think a lot of the problems associated with research that is presented to the board or presented to the examiner fails to accurately follow this dictate. So we're going to revisit this in a number of different applications, as you'll see today. But for now, let's talk about the process. I mean, here's how it works. I know a number of you have gone through this process before, but for those that may not have gone through the process of developing survey research, this is kind of how it generally unfolds. So Trademark Counsel identifies the issue calling for research. It could be that we need to develop secondary meaning studies or likelihood of confusion or deal with genericism. So we identify that specific issue, and then we retain an expert to design an appropriate questionnaire, to design the survey itself. Counsel and expert typically identify the appropriate survey population whose opinions are relevant to the issue at hand. The survey is then launched, oftentimes online these days, as compared to the old days of dealing with mall intercepts and other types of in-person interviews. But the surveys are launched. Survey responses are then collected and analyzed by the expert, and a written report is issued. And then the examiner and or the TTAB find the survey results persuasive, and everybody's happy on your side. So that's ideally and generally how the process works. It oftentimes doesn't unfold in that way all the time. Timing and costs. Give yourself, I would say, ideally 60 days from start to finish. So let's say you have your back up your expert disclosure deadline. If it's October 1st, you should back that up by 2 months, and you should hopefully be starting by then. Ideally, even more time. More time is always better, just based on everybody's schedules and how life unfolds for us as practitioners and experts. So yeah, I'd say ideally 90 days, but certainly 60 days, it's possible to get survey research conducted, fielded, and analyzed and issued in a written report. But it does take time to address a number of items. I also think one of the issues that we see here is maybe counsel and experts were harried a little bit, were rushed for time, and didn't necessarily have time to think through some of the nuanced issues that we'll talk about today. So it does take time to address those. Typically, there's back and forth on survey design. Are we using the correct survey design? What is the correct survey population? These sorts of very important critical aspects of survey research. Then, of course, it takes a while to collect the data. Oftentimes, if it's kind of rank and file consumers that you're trying to collect data from, it can be relatively quick. But if it's, again, more nuanced audience or harder to reach audience, it can take a while to collect that data. And then it's going to take some time to review the data, issue a written report, and so on and so forth. So give yourself ideally 60 to 90 days. Costs of survey research, as many of you know, are really dictated by two things. It's the cost of the data collection, and it's the cost of the expert's time for conducting the survey research. I can't say there is an absolute rule of thumb, but I would say for most, most survey research projects that require you to collect data from rank and file consumers, as I will refer to them, you're probably looking at somewhere between $30,000 and $35,000 per survey, and that would be through conducting the survey research through an issued written report. It can be more than that, but that's generally speaking a rule of thumb that I think you can pretty much expect. Best practices and standards in conducting research. I do want to reference a couple of resources for you. There's the Dr. Sherry Diamond Reference Guide on Survey Research. It's part of the larger compendium that's put out by the Federal Judicial Center. Highly recommend that to you. Trademark and Deceptive Advertising Surveys. This is a very useful handbook. A number of authors from across the litigation spectrum that have helped put this together. Very insightful, very practical. I recommend it to you. There's also the American Association for Public Opinion Research, or APOR, that puts out a best practices guide. I recommend that as well. And then this recent work that came out last summer, Marketing and the Law. This is maybe a little bit beyond the scope of what we're talking about today, but this deals with some of those more esoteric related survey issues, conjoint analysis, damages surveys, class action certification surveys, and the like. So those are some very handy resources that I recommend to you. Okay, so now let's talk about the pitfalls to avoid, and we're going to try to get through all 10 of them. The first one I want to mention is internal marketing studies. Now, what I mean by internal marketing studies is exactly as you suspect. These would be marketing studies that are conducted not for purposes of the opposition or cancellation or examination proceeding that's happening, but internal marketing studies that the client keeps in its ordinary course. Now, the board does like this kind of evidence. You see here from a case I quoted dealing with the Chanel trademark. The board will consider pre-litigation internal marketing studies. And you'll note here at the end, the board says the fact that these surveys offered by Chanel were commissioned prior to the instant litigation and were used in the ordinary course of business increases their probative value. So consider whether your client does have internal marketing studies that can be put to good use for purposes of the proceeding at hand. But be careful. And here's a really good example of what we oftentimes will see when parties offer internal branding or marketing studies. So this was an opposition involving Bowmaker's whiskey. It applied for distilled spirits for Bowmakers, and it was opposed by Maker's Mark. Now, during the course of the proceeding, Maker's Mark wanted to show that it had commercial strength. So it submitted this annual brand awareness study that was conducted by its marketing firm, kind of in the ordinary course of business. It's something they did once a year. Now, the report showed 69% of those respondents aged 22 to 59 were aware of Maker's Mark. So on its face, superficially, you would think, okay, well, this is going to be potentially some persuasive evidence that we need to get in front of the board. Now, unfortunately, the board gave the 69% finding little weight because the methodology wasn't explained. There was no indication as to what questions were asked. Were they clear and non-biased? And also importantly for this proceeding, what were the respondents shown? Were they shown just the Maker's Mark, the word mark? Or were they actually shown the bottle itself that has the red wax at the top, which is also an indicator of source? So the 69% figure didn't have context for the board. Very recent decision. I know John blogged about this at the TTAB blog. Another case involving the use of internal marketing studies that was used. So applicant here applied for just don't do it, get it done for clothing and apparel products. Of course, Nike opposed it on likelihood of confusion and dilution grounds. Now, Nike attempted to use a historic events survey as proof that consumers recognize the Just Do It mark. And Nike attached the results of that survey to a declaration. And they showed that 79%, or this is the argument, 79% of consumers recognize Just Do It as the slogan used by Nike based on this survey question that was posed to respondents. I'm going to give you the names of 3 companies. Tell me if you know which one uses the advertising slogan, Just Do It. Coca-Cola, Nike, Levi's, don't know. Now, what was also attached to the declaration is this evidence here. There was a fax cover sheet that was attaching the survey that was done. There was a data table you see there in the middle, and then the survey questions. And that's all that the board had to consider in terms of the propriety of this survey research. Now, the board didn't mention it, but I wanted to point this out. This survey was conducted back in May of 1999. This opposition proceeding was launched sometime, I think, in 22 or 23. So query, and I point this out, the board didn't mention it, query whether the survey research or the internal marketing studies that you want to use are actually stale. Are they relevant? I'm not saying that this wouldn't have been relevant based on other evidence that was presented, but in any event, think about when was this particular marketing study completed, and is it germane to the issue at hand today? So what the board said is it said this was of dubious probative value, the survey research, because again, there was no indication that any of the particulars about the survey research were disclosed. It was just that information that I showed you with the fax cover sheet and the data table and the survey questions. No indication as to what sampling process was used, any sort of statistical analysis done with respect to the results. So again, I hearken back to the Trademark Manual of Examination Procedure, which I think can be really helpful. You got to make sure you document the procedural and statistical accuracy of this type of evidence and carefully frame the questions contained therein. I want to contrast internal marketing studies with expert surveys conducted for that case. Of course, there's a difference and it matters. Here was a case involving Everwild, applicant for distilled spirits, opposed by Everclear. Now, applicant wanted to introduce a brand survey, but it was conducted for that proceeding. And it wasn't disclosed as part of the expert witness disclosures. And ultimately, the board declined to consider it. Because look, if you have developed survey research for that particular dispute, it's not an internal brand study. It's used pursuant to the procedures in that case. And so you need to make sure to disclose it during and pursuant to the scheduling order issued by the board. Okay, pitfall number 9. Careful when using third-party marketing studies. Now, this is a case where the applicant applied for Siren's Brew for coffee and t-shirts. Now, their use dated back to 2018, and that's going to be important. This application was opposed by Starbucks, which has used that two-tailed siren design going back to 1971. Now, Starbucks alleged both likelihood of confusion and blurring with respect to its opposition here, and relied on a number of these versions of the two-tailed siren. Now, as part of its attempt to show fame for dilution purposes, Starbucks relied on 3 different third-party brand value rankings. You see them listed here. It came in at number 24, number 31, and number 45, respectively, with respect to these third-party brand value rankings. But the problem is that the TTAB found that these rankings had a lack of clarity as to what were they referring to. Were they referring to the brand value of the two-tailed siren? Were they referring to the brand value associated with the wordmark Starbucks? I mean, what exactly was at issue with respect to those brand surveys? And importantly, all 3 were from 2019, And so they didn't bear on the issue of fame as of the date that the applicant started using the mark in 2018. So the dilution claim was dismissed there. So if you're relying on brand rankings or similar studies by third parties, you got to make sure that those can be tied to the mark at issue, and then also consider the issue related to timing. Pitfall number 8, be mindful of using an industry expert instead of a survey expert, or should I say, be mindful of using an industry expert who will then opine on consumer recognition of a particular mark. So that came up in this recent decision involving the application for Mossy Oak. It was opposed by Royal Oak, which produces these, is the company put out by the company that produces these high-end watch pieces. And the expert in that case was an industry expert who tried to opine that, look, consumers have this longing for luxury goods and apparel products that they can't necessarily have. And because we have a very well-known, renowned watch, consumers are likely to want to have that, and therefore this is recognized by consumers. And of course, the TTAB gave this testimony a little weight because it was more anecdotal, wasn't based on any sort of data. There was no indication that any of these experts had any sort of experience with brand recognition surveys. So wanted to mention this one just because I think it's an important issue that I do see come up quite frequently, where you're trying to use an industry expert to opine more broadly in terms of what consumers think. So you need to be careful and resist that temptation to have an expert opine more broadly outside of the scope of his or her expertise. Okay. So using a non-expert to develop survey evidence. This is another issue that I actually have seen come up in a number of different contexts, not just at the TTAB, but in federal court. I'll give you a quick run through of what happened in this particular case. So the applicant applied to register the color green for this particular glove. This was the drawing that was submitted to the PTO. They tried to develop survey evidence, and during the course of developing the survey evidence, showed this, the bottom picture, as the survey stimulus. So it actually wouldn't be appropriate to show this as the survey stimulus when you're applying for the mark above, and that is the drawing that was submitted to the board. But there are other problems associated with this, quote, so-called survey evidence, which, by the way, if a court or the board refers to something as so-called survey evidence, you know what follows is probably not going to be so great. And sure enough, there's a list of things here that the board found were problematic. The researcher that conducted it had no survey credentials. The improper universe was surveyed. There was leading and improper questions, and as a result, the TTAB gave that survey no weight. By the way, I wanted to mention, if you're rebutting a survey, do I need an expert? Sometimes you don't need to do so. You can just rely on case law and other arguments that you can point to showing that this particular survey research was not done consistent with appropriate standards as articulated by the board. But the board has also said, look, if you can add to that and have a rebuttal expert that can further explain and refine for us what the problems were associated with that research, that's a good idea too. So not absolutely necessary, but it can be a good idea to further bolster your claims and criticisms. When we're speaking about rebuttals, how many rebuttals do we get when it comes to survey research? This is a recent case I just wanted to mention briefly. The applicant, Monster Light, opposer, Monster Energy Drink. Monster developed survey research, as you see here on the timeline. Monster Light provided a rebuttal report. Monster provided a SIR rebuttal, and then Monster Light provided a SIR rebuttal. So the question was, well, how many rebuttals can be submitted to the TTAB? Ultimately, the TTAB said, look, we're not going to consider a SIR rebuttal. That's just a bridge too far. Okay. Pitfall number 6, selecting the wrong confusion survey method. So I'm going to just briefly touch on the two the most common ways to test for likelihood of confusion. I know some, if not all of you, are familiar with these, so I will go at a gallop here. There's two methods. There's a squirt and there's the ever-ready methods. So the issue in the squirt case was whether the lemonade drink Quirst, pictured there on your screen, infringed on squirt. So Squirt Code developed what is now called the squirt method and conducted survey research. And in the original survey design, survey respondents listened to radio commercials for each of these products pictured here on the screen. For Squirt, and then Lysol, Quirst, and then a chat. I don't think it was a actual Cheese Whiz, but it was a Kraft cheese product of some sort. And then they were asked a series of questions, including, do you think Squirt and Quirst are put out by the same company or by different companies? And you see 34% thought the same, 55% thought different. So the Squirt survey format shows both the senior users mark, Squirt, and the junior users mark together or in close succession. So that's really the hallmark of the Squirt design. It can be an appropriate method in those cases where the parties' goods or services appear together or in close proximity in the marketplace, or consumers are otherwise going to encounter one soon after the other. I want to contrast that with Ever-Ready. Ever-Ready is the survey method that the board has said is essentially the gold standard in cases, particularly in those cases where the senior user's mark is top of mind or is well known in the marketplace. So here's how Ever-Ready works. So of course, Union Carbide has been putting out Ever-Ready batteries dating back to the 1890s. Back in the 1970s, a company called Ever-Ready started putting out lamps and lamp bulbs under the name Ever-Ready. So Union Carbide developed survey evidence and essentially showed those junior user marks to survey respondents and asked them a series of questions, including, who do you think puts out these mini bulbs? And please name as many other products, or please name any other products put out by the same concern, which you think puts out these mini bulbs. 53% said batteries. So with respect to what's happening here, is Ever-Ready surveys do not show the senior user's mark to the survey respondents. What they do show is the junior user's mark and then ask a series of questions. So contrast that with Squirt, where both parties' marks are shown. Here, when it comes to Ever-Ready, you just show the junior user's mark. There's a number of other differences between the two, but those are two of the key differences, or one of the key differences that I want to highlight as we talk about the rest of our cases today. Okay, so which format should I use at the TTAB? Should I use Squirt or should I use Ever-Ready? Well, let's look at a recent case involving that exact issue. So applicant applied for Gilead Capital for investment management and financial services. An opposer, pharmaceutical company, Gilead, had multiple registrations for health insurance consultation, pharmaceutical preparations, and various other related services. Now, opposer offered a Squirt-style survey to show confusion. And this is essentially the structure that was followed. You see here, this was a card that was provided to survey respondents. It had Gilead Capital at the top, and then it explained what Gilead Capital was used for, hedge fund services, investment advisory services, and the like. So that's what survey respondents were first shown. Then they were shown cards with the 4 names here on the left with the description as to what that particular company does. And then they were asked the series of questions. Do you think this company is the same company or a different company than the one whose name and description you were first shown, or do you not know? Now, ultimately, the survey research showed about a 15% net confusion rate, but the board said that it lacked marketplace reality. Now, why is that? Because remember, Squirt is really only to be used, or should be used, confined to those instances where the parties' marks appear together in the marketplace. And as you see here, Gilead Capital for financial related services and Gilead for pharmaceutical products and services, no indication that those parties' marks were going to be encountered by consumers at the same time. So again, recall that if the parties' marks appear together in the marketplace, Squirt might be squirt might be the more appropriate method. If they don't, you can consider if Eveready is the better fit. And sometimes a case just isn't appropriate for either method, so you need to consider that as well. I'm going to, just for the sake of time, I'm going to bypass that particular case and get to pitfall number 5, surveying the wrong people. In other words, selecting the wrong survey population. Now, I'm using this case from about 10 years ago because I think it has a teachable moment and an important one that you need to consider when you're developing survey research potentially for submission to the board. Now, applicant here sought to register Sparkle Life for jewelry. Now, important, there were no limitations on the channels of trade or price points or any sort of limitation in the goods and services description. Opposer developed survey research to show that there would be confusion between splashes and sparkles and Sparkle Life. Now, there wasn't necessarily anything wrong, and I'll kind of go through these slides rather quickly. You can see them on your own. But I want to cut to the chase on this particular survey population that was used. You'll note here that the expert limited the universe of respondents to people interested in purchasing or who have purchased women's jewelry in the price range of $25 to $249. Now, maybe in the marketplace, that's the target customer. But for purposes of conducting survey research and submission of it to the board, you got to consider the goods and services description. There was no sort of limitation that was set forth in the goods and services description. So the survey population should not have been constricted. It was too narrow. So important to consider goods and services description in certain cases, particularly when it comes to selecting the survey population. Now, on the other side of the coin, sometimes survey research has been submitted to the board that was too broad. It was over-inclusive. So applicant here sought to register tequila as a certification mark. Opposer claimed that it was generic, conducted a survey to show that, and the board said, no, that's too broad of a survey population because you didn't just limit your survey universe to potential or actual tequila drinkers. Or you should have done that. Instead, you were too broad in your application, and your population included all drinkers of hard liquor. Again, you should have been more focused and streamlined on just potential tequila drinkers, because just because you are a drinker of hard liquor doesn't mean that you are going to be a connoisseur of tequila. Okay, so again, another careful consideration to be thinking about when you're really analyzing what is the proper survey population for this particular study. Okay, selecting the wrong stimulus. All right, so most surveys that are presented to the board, well, all surveys are going to have some sort of stimulus. Sometimes the stimulus is an image, sometimes it's a word mark, sometimes it's a combination of both. Now let's look at this case that started off before the board. Timberland, the applicant, or TBL licensing, sought to register this particular trade dress for this boot configuration. The examiner denied it, saying it was functional and also that it lacked acquired distinctiveness. The board affirmed on the lack of acquired distinctiveness. So instead of appealing that decision to the federal circuit, the applicant actually started a de novo proceeding in federal court in the Eastern District of Virginia. Now, to get over the issue with acquired distinctiveness, it conducted a secondary, or lack of acquired distinctiveness, I should say. It conducted a secondary meaning survey. And the stimulus that was shown to survey respondents was the actual boot itself that appears in the marketplace. Now, the court said, look, that's the wrong stimulus. Now, whereas you might show the actual product, a stimulus to survey respondents if this was standard federal court litigation, but we're not here dealing with standard federal court litigation. What we're here on is the issue of registrability. And because you sought registration of that particular drawing, that should have been the proper survey stimulus that was used, as opposed to the actual boot design. Another interesting decision came out earlier this year from the board involving Fruity Pebbles. So now Post sought to register this multicolor mark. You can see here during the course of the prosecution, this is how they defined, and they amended the description of it. But this is the description of the mark that they sought to register. The mark consists of the colors of yellow, green, light blue, purple, orange, red, and pink, applied to the entire surface of crisp cereal pieces. The broken lines depicting the shape of the crisp cereal pieces indicate placement of the mark on the crisp cereal pieces and are not part of the mark. So in other words, the shape, the application was agnostic as to the shape of the cereal. It was really just seeking to register this multicolored scheme, regardless of what the shape of the cereal was. Now, they developed survey research, the applicant did, to try to show that Fruity Pebbles had acquired secondary meaning. And this is the actual, one of the stimuli that was shown to the survey respondents. And the TTAB rejected the survey. It said it does not provide evidence that the claimed colors have acquired distinctiveness for the identified goods, that is, all breakfast cereals, including other non-crisp rice cereals in other shapes. So again, it didn't quite align with the evidence there. So I think a couple of important takeaways with respect to those two cases. Consider your venue in terms of what the survey stimulus is that you need to be showing survey respondents. It could differ, and rather dramatically so, between whether you're at the board or in federal court with respect to a registration issue, or if you're in federal court with respect to a commercial dispute between two competitors. What's going to be at issue in those two cases will dramatically affect what you're going to show survey respondents. And then on the Post Fruity Pebbles case, make sure that the stimuli that you're using for your survey research is ultimately going to line up with your evidence. Pitfall number 3. The survey doesn't show robust results. So this was a case involving a claim of dilution. Applicant sought to register Sky Guard. You see it here on the screen. Opposer was Sky Vodka. Now, survey research was developed in that case, but for fame purposes, you really need to show something along the lines of 75%. Remember, the standard for fame is really high. It's got to be well recognized by the general consuming public of the United States. So, you're talking rarefied air there in terms of the amount of recognition you need. Even though something might be sufficient in terms of recognition for purposes of secondary meaning, it's going to be different for purposes of fame. So make sure you keep that important distinction in mind between those two. Pitfall number 2. So let's talk about genericism studies here for a moment. As I mentioned at the outset, I think this is a topic, particularly with some of the recent cases, both out of the TTAB and in federal court, where you could really do a full-blown webinar unto itself. But let's talk a little bit about some of the recent cases involving genericism, because it comes up a lot. And I think we are beginning to see some of the similar problems and pitfalls associated with this type of survey evidence. So for those of you that may not be familiar with Teflon, there's 2 types of methods that we generally think of in terms of establishing or dealing with the issue of genericism. There's the Teflon method, and there's also the thermos method. Teflon is by far and away the more popular method that is used. So Teflon method, of course, comes from a case involving DuPont's Teflon back in the 1970s. YKK came out with these Efflon for zippers. And Teflon, of course, sued. Efflon defends on the basis of, hey, Teflon's become generic. And so we should be able to use Efflon for our zippers. Well, DuPont was not going to take that line down, of course, and it developed what is now considered and referred to as the Teflon method of establishing, or in this case, defeating a claim of genericism. So here's generally speaking how the Teflon method works. What you do is the researcher provides a little mini primer to the survey respondents and explains what the difference is between a brand name and a generic term. And in the Teflon case, Chevrolet was used as the name of the brand versus automobile for the generic term. And then once you explain the difference, you typically provide them with a little mini test that explains or that shows that they understand it, the difference between a brand name and a generic term. And if they pass that mini test, they go to the next round and complete the survey. And here are the results from the Teflon case. You see here I've highlighted that 68% of the survey respondents believed that Teflon was a brand name versus 31%. And because a substantial majority of the public continues to believe that Teflon is a brand name, that was good enough for the court. So that is essentially the Teflon method at a high level. I wanted to set that context for the next couple of slides here. All right. Reservations.com. This was a recent decision by the board where a genericism study was offered to overcome the examiner's refusal to register the mark. The applicant produced a Teflon study showing that 60% of respondents believed it was a brand name as opposed to a common name. Now, there are a couple of problems. I'll just highlight them. I would commend this decision to you if you are considering developing a genericism study for use at the board. Take a look at reservations.com. I think it highlights some of the big problems that the board has seen with survey evidence recently, at least in the context of genericism studies. So here are the results that were produced to the board. There was some fairly significant missing data here in terms of how many percentages of consumers found reservations.com to be a common name and how many didn't know. But I think maybe more problematic for the board is that the mini test that was used to test whether consumers understood the difference between a brand name and a common name only included a couple of .com examples. What the board said is, we think that the mini, like the little mini primer that you did in the test was ultimately flawed by virtue of the fact that 42% of those that participate in the study found that washingmachine.com was a brand name. So from the board's perspective, there was something wrong with the little mini primer and the mini test that was ultimately issued to the survey respondents. So that can really trip you up along the way, as we're going to see again in a moment here. I wanted to briefly mention the sensory path. This was a case where survey research was offered. I guess I would call it nominally a Teflon survey. I don't know that it necessarily fit right there in that category, but in any event, what the TTAB said with respect to this particular genericism study is there was no mini test that was provided to the survey respondents. So there was no way to gauge or really accurately look at the final data and see if people understood what the difference was between a common name and a brand name. So that mini test, as reservations.com tells us and as the sensory path tells us, is very, very important. This case just came out a couple of weeks ago. Now, it's another one of those cases that originated before the board, but then ultimately wended its way through up to the Central District of California. So Snap has been using spectacles since 2016 for eye wearable technology. It sought to register spectacles essentially for smart glasses. The board, the examiner refused, and the board upheld the refusal to register because it was either generic or it was descriptive with no secondary meaning. So Snap didn't take this lying down. Like I mentioned, it started this new proceeding before the district court. And it developed two different Teflon surveys. Now, I'm just going to focus on the second one for purposes of today's discussion because they both contained similar flaws and problems from the court's perspective. So the format included, as it should, a little mini course, as we've kind of talked about. It contained the mini test, and then survey respondents that qualified took the main test involving the spectacle applied for mark. Now, here are the results from that second survey. Oh, and I should mention, this survey, apologies, was developed by the PTO. So it was submitted by the PTO to show that the mark was generic. So according to the PTO survey, 72% of those that were surveyed found that spectacles was a generic name. Now it's a little bit lower, but similar to other generic names that were part of the survey, as you see here. Quite a bit different compared to the names of brands that were also part of the survey research here. And so I recommend this decision to all of you because I think the court really goes through and takes a very close look at this survey research and discusses it in detail. Had a number of problems, but I just wanted to highlight two of the issues that the court said because I think they're particularly salient here. So the court said, look, what you're doing, board, is you've presented this survey research to us as kind of an all or nothing proposition. It's not necessarily binary in that consumers view it as either a brand name or as a generic term. What the court said is this doesn't take into consideration if consumers could think of these as potentially descriptive marks that are potentially registrable. You know, the survey research, the data, the questions that were asked of the survey respondents just simply don't get to that issue. So the court was troubled by that particular aspect of it. But then the next aspect that I think the court was probably even more concerned about is what I would say is kind of a systemic problem associated with the entire structure of the survey itself. Now, the court said here is, look, you've really primed respondents to come to the conclusion that you want. Not in so many words, but that's my take on what the court said here. What it said is, look, when you're taking them through the mini course, you're using brand names that are well known or they're fanciful and arbitrary, and then you're contrasting those with clearly terms that are generic. So you see here in the first table, iPhone, Hero, and Think Reality were the brand names that were used versus smartphone, camera, and smart glasses. So that was the mini course example. And then in the mini test, again, it was more fanciful and arbitrary brand names that were used versus very common names, display and eyewear. And then in the main test, suffered from these same problems according to the court. You've got Vision Pro, Echo Frames, and Blade as the brand names, and then generic names, camera glasses, Wi-Fi glasses, and lenses. So what the court said, look, by the time they get to the main part of the test, and they've been kind of preconditioned that brand names are these fanciful and arbitrary names versus these very common names, you know, the court said, look, there's really no question how they were ultimately going to come out. So again, I recommend this case to you. I think it's a really good example of problems associated with genericism studies that need to be thought about and carefully scrutinized and considered. Okay, last pitfall I want to talk about. It deals with failure to function refusals. And I want to call out and commend to you this article written by Charlie Henn of Kilpatrick, Townsend, and Stockton. I thought it was a very insightful article, and I wanted to reference it to you. This was a case involving a failure to function for Pound Law, which is application to register Pound Law by Morgan & Morgan, or I think it's licensor, with respect to legal services, a way to phone, a way to advertise legal services for people to call. Now, it was refused by the examiner, ultimately affirmed by the board. And again, one of these civil proceedings that was initiated to overcome that refusal. And it discusses in the article about the survey research that was conducted in that case. And it looks somewhat similar to a Teflon type of survey, in that they were trying to show that this particular mark actually functions as a trademark and consumers perceive it as such. So they started off with providing the little mini trademark primer, much along the lines of what we've talked about in the context of genericism studies, and then provided some examples. For example, the word Subway functions as a trademark when it is used by one company to sell sandwiches, but Subway does not function as a trademark when it refers to a train system that runs mostly underground. So there were a series of examples that were provided. Then they provided the test. Remember the little mini trademark test here, similar to the test in the context of a genericism study. And then asked, looking at the advertisement shown here, what, if anything, functions as a trademark? 99% of the respondents were able to appropriately identify a trademark. And then they were asked, after they qualified, they're shown a series of images. There was a test condition and a control condition. But the bottom line is that this particular survey format yielded results showing that survey respondents, approximately 25% of them, perceived Pound Law as a trademark. Now, the survey research was shared with the PTO during the civil proceeding, and ultimately the PTO agreed to withdraw the failure to function refusal. So again, if you're dealing with a failure to function issue and you're considering different survey methods, this was a new method that was proposed in this case. It appears to have been successful, appears largely based on the Teflon method. So something to consider in your practice, because at the end of the day, look, Pound Law was ultimately successfully registered. That concludes my formal presentation here. I want to again thank you for attending. I want to reference the QR code and Lanham Act surveys for lawyers. Feel free to reach out to me directly. You've got my numbers there. You've also got my email. If you do need CLE credit for today's presentation, make sure you return that completed sign-in to attendance@dorsey.com, and then you will get your special little certificate showing that you participated and you were here today. And then again, the materials are available for download from that email that was sent earlier. Here's a quick legal notice. And I think that's all I have for you today. So thanks very much, John. Again, it's a pleasure to collaborate with you on this, and appreciate the honor of the invitation to be here with all of you.